Good day and welcome to today's webinar. I am May Turnbull, one of the directors at EasySAM, and today I'm joined by the lovely people from Addleshaw Goddard. Today's aim is to introduce you to the two companies and how we work together, whilst imparting you with some knowledge around software agreements. EasySAM are an independent software asset management consultancy, so this means no hidden agendas. We don't sell licenses or partner with any specific vendor or tool provider. So our sole focus is to drive down costs for our customers and reduce compliance risk, all while optimizing existing spend to produce return on investment for our services for those companies. Without further ado, I'm going to pass you over to Addleshaw Goddard for some introductions and to kick things off.
A little bit about Addleshaws. We are a full-service international law firm. We're particularly well known for IT-related legal advice, including software licensing and cloud deals. I'm joined today by Priscilla Heatherton, who's a senior associate in my team, and we deal with the prenup stage, so that's drafting, negotiating contracts and software licenses. And also with us today is Bill Gilliam, who's a partner in our disputes team, and Anuj Patel, who's an associate in Bill's team. They deal with the divorce stage, so worst case scenario litigation, but more often than not sitting in the background and helping our clients to manage disputes through to a successful resolution. If we could move on to the next slide, please. So we collaborate with EasySAM, and together we identified a gap in the market. No one is properly joining up the technical, legal and commercial aspects of software licensing issues. And as you can see from the Venn diagram that's on the screen now, what we can offer is exactly that, a fully joined up solution or service for our clients. And together, the impact of joining the dots, it enables our clients to achieve better resolutions when managing their software assets. What we're going to do for the rest of this session, though, is just to give you some tips on some of the common issues that we see, from entering into contracts through to litigation side of things, and also some of the commercial and the technical aspects that May and Robbie are going to talk to. If we could move on to the next slide now, please. Thank you. So first of all, it may sound simple, but check that you've got a signed contract and that you know what T's and C's apply. Watch out for embedded terms, so whether that's links through to product T's and C's or links through to policies, usage policies, or the flow down of other third-party terms. We often find that there are legal provisions hidden within these, whether they cap out liability or whether they're exclusions or restrictions on use of the software. So it's always worth clicking on those links and checking what they say. Take care on renewal as well. We find that software vendors often seek to incorporate new T's and C's at this stage. Likewise, during any change control process, that's often operational in nature, variations being agreed without lawyers present, and again we see software vendors trying to rewrite the T's and C's through those change control variations. But I think most importantly, take time to understand how the T's and C's actually apply to your usage of the software. In this day and age, with the integration of multiple applications, increasing use of cloud solution, it's always worth checking whether there's any indirect use of the software that could trigger additional license fees under the contract or the license agreement. We're going to touch more on indirect use later, so I won't say more on that right now. But on the under licensing side of things, when it comes to audits and the subsequent under licensing claims, this is, particularly over the last couple of years, becoming a growing source of revenue for vendors. I think we've been hit by Brexit, we've been hit by the global pandemic and a reduction in IT spend. So audits are becoming more important to software vendors as a way for them to maximise their revenue. Now, we see claims regularly being paid without question. We see audits often being used as a phishing exercise, and in particular, a word of caution, just to beware of resellers or other third parties who are associated with the software vendor playing prisoner's friend. At the end of the day, it's in their interests to drive more revenue for the software vendor, so they're not necessarily on the side of the customer. The good news is, though, that your contract is often your friend. So if somebody, one of the software vendors is seeking to do an audit, check your contract first, check the scope of the audit rights. What are the software vendors actually entitled to do? Also, think about legal privilege. So one advantage of Addleshaw's and EasySAM collaborating is that any health check or audit support that we provide together is legally privileged. So if you do end up in a serious dispute, you don't have to disclose all of that information to the software vendor. Next slide, please. Just continuing on the theme of things going wrong for a moment, Priscilla, do you want to share some thoughts on liability and risk?
Yeah, thanks very much. So where does the risk sit if things go wrong? Can be a very complex question. Can't cover that all off now, but just a few high-level key points that I'd suggest looking at when doing a legal review to try and shift the benefit of the contract more in the customer's favour is looking at the liability clause. Does the cap cover the whole solution, or is it being sliced and diced? Because it's sometimes a way that a supplier segments their liability by having the cap only attached to certain aspects of the solution that have gone wrong. And does the SLA protect actually the customer or the software vendor? So another way is that suppliers can use to box off their risk is use service levels. So a service credit regime might look attractive to begin with, but check whether it's sole remedy. So for example, that would mean that you'd lose your termination rights and damages claim, and credits by themselves are often not an adequate remedy and won't reflect financial loss. So we often see retention of termination rights if things go past a particular threshold, or ratchet mechanisms. There are other ways that can be used to move that more in the customer's favour. Change control. So Simon's already mentioned the risks on variation and renewal of things slipping through the net and not going with the negotiated terms again, but rather the standard terms. But also be aware of risks in embedded links, which can include extra sole remedy wording or extra liability caps, for example, and the risk of unilaterally amending, the supplier having the right to unilaterally amend a contract or the solution to the customer's detriment, for example, by changing the specification. So we'd always recommend extra controls on there, and preferably consent. And lastly, I just briefly wanted to touch on termination and suspension rights, because expiry dates can be used as leverage by software vendors to improve a commercial position, for example, by threatening to switch off the lights just as you're coming up to renewal. So it's important to diarise and plan in advance. And similarly, suspension rights can also be used as that threat of leverage. So important to get some extra controls in there, for example, relating to notice or being more specific about what can be suspended. And I really wanted to finish this slide by really stressing the importance of planning for exit. It's often not a conversation that people want to have up front because it can be awkward, but it's really important to plan as to how you're going to transition away from a solution. How long would it take you? What support would you need? And it's especially becoming more important in a regulated environment, for example, for financial services clients, with an increased focus on planning and testing these exit arrangements. But that's also just generally good practice for clients in other sectors too. So conscious that was a whistle-stop tour of those 3 points, but I'll hand over to Bill now and the next slide for a different perspective.
Thanks, Priscilla. So if Simon and Priscilla have talked about the prenuptial side of the relationship, so getting your contract sorted out when you're getting a project underway, this is much more about the life cycle of that contract and potentially what to do if you need to exit from it and move to a new supplier. So I will deal with the contract lifecycle, particularly in terms of software under licensing claims, which are a major issue for many clients. And then Anuj will deal with the exiting of the relationship if and when that is required as your needs and requirements develop. So in terms of software under licensing, AG have done the only reported UK case, which is SAP and Diageo. We acted for Diageo. Diageo got a very successful result in that, resulting in a reduction in the claim that SAP were making of £55 million to an absolute fraction of that, which was then successfully leave was sought to appeal, and a confidential settlement was achieved to Diageo's advantage. In terms of the lessons for the wider software community, if you're a customer, it's that these issues are well worth looking at, and if care is taken, you can save millions of pounds in relation to claims which have limited or potentially no real legal foundation. And that technical and legal work that we do with EasySAM is a good example of adding real value in terms of the saving that you can make to your estate and your operations. This is a busy slide as a placemat. We normally go through with our clients individually on these things in terms of your own environment and your own particular issues, but the central graphic is one that you'll have seen earlier in one of Simon's slides, where you've got the database, which may be, for example, an Oracle database at the bottom, business software, which might be, in Diageo's case, was SAP, for example, but we deal with all of the various suppliers, big IT suppliers. And then you may have a situation where you've got at the top employee software, so sales software, customer software in terms of ordering, and supplier software in terms of warehouse and logistics coordination. That comes down into that integration interfaces, and there's a real risk that employees, customers or suppliers are indirectly using that business software in the second box up. Now, the users of your organisation who may be directly using to the left and right of that will almost inevitably have licenses. You may not have all the ones you need, but certainly at the top end, that risk of those employees, customers and suppliers being allegedly indirectly using your software and therefore requiring licenses can give rise, and does give rise, to major claims. SAP and Diageo is the tip of the iceberg, and we regularly advise on these issues. On the left and the right of this slide, we've got some of the key issues to bear in mind and some of the solutions. Many of these we've touched on briefly in this session already, and we won't, for reasons of time, go into detail, but we're always very happy to talk to our clients or potential clients about these issues. The key message is really to reinforce from what Simon and Priscilla have already said, and on an ongoing basis, are to watch out for issues where, despite you having negotiated a contract with a supplier, those terms vary because the supplier is giving you free software or reduced price software in return for varying the terms and conditions, often to your detriment. It's also very important to treat audits very carefully, so don't delegate to a junior who just provides the wrong information to the software supplier, because that will trigger a potentially large claim, and trying to retract that information and correct it is a much more difficult job than getting it right first time. There's also that ongoing management that's really important in terms of your software estate, and just watching out as you're adding new third-party software, whether it relates to employees, customers or suppliers, how that interacts and how that affects the contract. And as Simon and Priscilla have said, it's really important to understand the teeth that you've potentially got in that contract that you can use to effectively just give the hand of the supplier a hard nip rather than biting it, but just making sure that things are being done in the right way. So being aware of your rights and exercising them and managing the contract in the right way is absolutely critical. You may, though, get to a point where you are looking to exit from the relationship in any event. That can give rise to software under licensing claims. It can also give rise to other issues. So if we just have the next slide, please, May. What we're looking at here is some of the tips and traps that you may fall into as you're moving towards effectively transitioning over from your existing supplier to the new one. And there's 5 key tips which Anuj is going to take you through in relation to that.
Thank you, Bill. Next slide, please, May. So our first checkpoint in the maze then is identifying the contract documents. Now, this sounds very obvious, but often causes problems, particularly when you've got a complex agreement, for example, different contracts for different regions or IT estates, or covering different aspects such as licensing, support and maintenance. Is the business looking to terminate the entire agreement or de-scope some of the services being provided? The commercial and technical teams should be aligned to ensure that termination of the contracts will not affect any ongoing business services. Our second checkpoint is exercising the correct termination right. This could be a webinar topic in itself, but termination usually relies on a provision in the contract, whether for convenience or for breach, or at common law for particularly severe or prolonged breaches. Based on our experience, I can't stress enough the need to ensure that you have the benefit of legal advice before terminating. Relying on the wrong termination right could result in the business having to pay the vendor for wrongful termination and risk losing its right to seek compensation for any losses. You may be aware, for instance, of the Phones for You and EE dispute, where EE lost its right to claim around £200 million for loss of bargain because it relied on the wrong termination rights. Next slide, please, May. So we move on to our third checkpoint, which is compliance with notice requirements. We've seen and acted on far too many cases where one party hasn't complied with the notice requirements in the contract. That often leads to arguments over whether the contract has been terminated at all, or whether the correct provisions have been relied on. Though it may seem trivial, failing to comply with these requirements to the letter can be fatal to termination. You must understand what's required in terms of format, time frame, and the specific addressees for a termination notice. It's also worth noting that separate contract documents may require separate notices to be served. It may be that different termination notices must be served for a license agreement and any underlying support and maintenance agreement. Notice to terminate can also be undermined by contradictory actions or correspondence. So it's critical that the business is careful to manage any lines of communication between the parties' commercial and operational teams. Given how important this is, it is vital that the business takes legal advice well in advance of giving notice to terminate. It's just not worth the risk of getting this wrong. Moving on to checkpoint 4 then, taking steps to smooth the transition to an alternative supplier. By this point, the business should have an alternative supplier in mind, if indeed it hasn't lined one up formally. We like to think of this process as jumping from horse A to horse B, and you'll have to indulge me with this analogy. So horse A is the current software vendor and horse B is the new alternative vendor. If you jump off horse A before horse B is alongside you, then you're likely to fall, and that is not where you want to be. The ideal scenario is one where horse B has caught up with and is running alongside horse A by the date of termination. You can then get rid of horse A and jump onto horse B in one smooth movement. So how can you achieve that? Well, make sure you're clear on what the contract says will happen on termination, including any requirements to hand up materials or delete data. Will a business critical system be switched off immediately? Or is there a grace period for the migration of systems, data and accounts? Identify with the alternative supplier's input what they'll need and make sure they have it up and running in time for the transition. Should you need the current supplier's cooperation, ensure this is agreed well in advance. If not specifically documented in the contract, it may be that the parties need to negotiate a variation which covers the required steps. As with the other checkpoints, ensure the lawyers are looped in as soon as possible to maximise the prospect that any transition requirements are documented and satisfied. Finally, we come on to our fifth checkpoint, which is considering any outstanding or potential claims or payments. Prior to termination, it's important to think about any outstanding payments or claims running either way. A strategic decision will need to be made on whether to try to settle any claims prior to termination or else whether to wait until after termination. And that may depend on different variables like the personalities on the other side and whether the supplier's cooperation is needed for migration. Whichever course is taken, it's imperative that rights are reserved and nothing is said which could prejudice the business's position in relation to payments or prospective claims. We often act on cases where there have been performance issues by the supplier, which the customer then wishes to pursue following termination. If that's the case, then it's crucial the trail has been papered properly and that the business has access to documentary evidence around breaches, defects or delays. It's worth making sure that access to those documents won't be lost or fall outside of the business's control post-termination. The better the records of factual events and documentary evidence of losses, the better position the business will be in to resolve any issues more quickly and cost effectively. Not to mention, it'll make the lawyers' jobs much easier. Next slide, please, May. So going back to the maze, hopefully we've brought this graphic to life. At the entrance and throughout, we have alongside the business, the lawyers wielding the sword to protect the business's rights, and importantly, the shield, which represents legal privilege. I'll now hand you back to EasySAM to discuss the more technical and commercial aspects of software license agreements.
Thanks, Anuj. Right, so from an EasySAM perspective, the three sort of flags we wanted to cover with you today are sort of key reasons why we see customers and organizations attracting unwanted attention from software vendors over the years, and they're quite easy and straightforward, but obviously often overlooked. So the first of the three sort of flags likely to trigger a software audit would be a sudden drop in software spend. So this is probably the biggest one, and is obviously has resulted in a number of different audits for our customers. And there are three sort of reasons why you would have a drop in software spend, or three reasons that the manufacturer might pick up on a dramatic decrease in your spend. So breaking free of enterprise level agreements and maintenance contracts, so sort of ties back in with what Addleshaw Goddard was talking about in terms of things to consider when exiting your agreements. When you're in an enterprise level agreement and you have that sort of a statewide commitment and you fall back away from that, it does drive suspicion on behalf of the manufacturer. The second is replacing your infrastructure with competing software. So we saw this a lot with the moves sort of a decade ago to Google. So open source and free of charge software. Obviously that would almost completely obliterate your software requirements in some situations. And then obviously the downsizing of the company, which kind of ties in nicely to the next point, which is a lack of communication. So if you are obviously communicating well with your vendor partner, and you're letting them know about things like changes in the organization, downsizing, acquisitions, which I'm going to get to in a little bit, then there's no reason for them to suspect or want to come in and ask questions. So although people are a little bit reluctant to have big or revealing conversations with their vendors, we at EasySAM 100% encourage it. Keep your vendors up to date, open the communication channels, and it can only result in some good negotiating from both parties. And then the last one, which is the organization growth, which I already alluded to. So obviously acquisitions and mergers are something that software is rarely spoken within those conversations, and it's probably the biggest bugbear we find when coming into customers to help after the fact. Is that obviously software isn't part of the conversation. Those conversations therefore haven't been had with the vendors. So it does, when the vendors do get wind of it, it does sort of spark curiosity. So one is the acquisitions and mergers, and secondly, it might just be to healthy growth. And this is where obviously communication within your company is absolutely crucial. You obviously have to have that relationship with your HR and your help desk to make sure that provisions are made for growth and that licensing requirements are considered and access is given out according to policy. So those three key points. So chat to your vendors, keep a good relationship with your resellers, make sure that obviously you avoid unknown growth or reduction in spend that might sort of trigger an audit of the organisation. So that kind of takes us to the end of our slides. We thank you all for joining us today. Before we go, does anyone have any questions? So I'm just going to check my chat here. All right, okay, I've received a couple. I apologize, guys, directly, and they all appear to be targeted towards Addleshaw Goddard. So guys, pick them up, as you see fit. So the first question is, when should I get someone like Addleshaw Goddard involved? I don't know if you guys.
Yeah.
Bill.
Yeah, I can take that one. So the short answer is the sooner the better. If you have any of those concerns, including the particular flags that we've highlighted and that EasySAM have highlighted in terms of reformulation of your environment, changes in the way that you're operating, particularly over the pandemic period, you may have some concerns that there may be some additional licensing risk there. And so a stitch in time, as it were, is helpful in terms of just advanced warning of what may be around the corner in terms of any audit risk. So we're always very happy, both EasySAM and AG, to have discussions about any particular concerns that you may have in relation to your environment. And as Simon's referred to, doing that and getting legal advice in relation to it does have that protection of privilege, which means that that doesn't need to be disclosed to your supplier. So it gives you a chance for a full and frank discussion, as it were, in terms of any potential risk and what may be taken, what steps may be taken to reduce or even eliminate that risk.
Brilliant, thanks for that. So the second one is asking sort of about stakeholders and departments. So it says, so what stakeholders or departments need to be involved early doors? So I think they're probably mentioning to, I'm guessing, the exiting of software agreements.
Yeah, I'm happy to take that one, and obviously Bill, feel free to chip in. So as I mentioned, I mean, it's important to get the technical, operational and commercial teams involved to understand what the business's requirements are and the precise kind of contract documents, licenses, etc. that need to be terminated. And crucially, you want to make sure that kind of business as usual is anything that's ongoing isn't terminated. And that there aren't any business critical systems that are going to be impacted by termination. So really getting AG involved, as Bill and Simon said, with the legal privilege and the ongoing advice and assistance, as well as the teams on the ground in terms of the commercial, technical and operational teams.
Brilliant. Thank you for that answer. And the last one, I guess this is a question for both EasySAM and AG. What software vendors do you have experience with? And I'm guessing that's an overarching question, both, I guess, dispute-wise and sort of a contract negotiation. From an EasySAM perspective, we have obviously a plethora of software vendors that we deal with. I guess the most predominant ones for us in terms of obviously what I spoke about audits would be Microsoft, IBM, SAP, those kind of vendors. I mean, we've been involved in some slightly smaller ones, but you obviously find nowadays the likes of kind of Adobe and those sort of manufacturers, the audits are fewer and far between. I don't know, AG, what your involvement mainly encompasses.
Simon, Priscilla, do you want to cover that off?
Yeah, sure. So, I mean, Addleshaw's, both our litigation and our commercial teams, we are predominantly acting for customers rather than the software vendors. And yeah, we come across all the major software vendors, all the ones you've mentioned: Microsoft, SAP, Oracle, Salesforce, IBM, and we come across them both in the context of the licensing side of things, software licenses, but also bigger transformational deals, infrastructure, hardware, data center outsourcing, managed service outsourcing. So yeah, we come across them in many types of agreements.
Great stuff. Well, yeah, thank you guys for those questions, and thank you to everyone that answered them so nicely. That sort of concludes the webinar today. We had originally only scheduled half an hour, so thank you for staying with us while we answered some Q&A. And yeah, you have our contact details, so if there's anything that you think of after the call, we are here and we'll be sure to make contact in the days to come.
Thanks, everybody.
Thank you.
Thanks, everyone.
Thanks all.
Bye.
Bye.